Good morning, and welcome to our first panel of the day. All too often, discussions of our early history go straight from the Revolution to the Constitution, skipping the Articles of Confederation entirely. But part of understanding who we are as a country is understanding what we tried and rejected, or preserved. The Constitution was written in part to fix the Articles' mistakes. I'm really excited for this panel as our chance to understand the Articles themselves, and it's going to help set the stage for the rest of the day's discussion about the Articles' long shadow. I'm Alicia Bannon, the director of the Brennan Center's Judiciary Program and its Kohlberg Center on the Supreme Court. And we couldn't have a better group here today to discuss the Articles and their legacy. Please join me in welcoming our panelists. We have Aditya Bamzai, the Martin Lubin Karsh and Bruce A. Karsh Bicentennial Professor of Law at the University of Virginia School of Law, right at the very end. Farah Peterson, Professor of Law at the University of Chicago Law School, right in the middle. Johann Neem, next to Professor Peterson, the Professor of History at Western Washington University. And right next to me, Jack Rakove, co-professor of History and American Studies and Professor of Political Science Emeritus at Stanford University. Thank you all so much for joining us here today. And before we get started with the discussion, I'd like to remind the audience that there will be time for your questions. So please write them down on the index cards that you were given and raise them at any moment, at any point for a staff member to collect. So Professor Bamzai, I'm going to have you kick things off and really help level set the conversation for this panel and really the whole conversation for the day, so no pressure. Can you lay out for us what were the Articles of Confederation? How did they structure the national government and the relationship between the states?
Well, thanks so much, Alicia, for the introduction. Thanks to the event organizers for including me and for all of you for being here. It's truly an honor to be on this panel with Professor Rakove, who's one of the great historians of the founding era, with my old colleague, Professor Peterson, and to make the acquaintance of Professor Neem. So as Alicia just mentioned, she's asked me to set the stage with some foundational information on the Articles. So this is my attempt to do that with the very basics. The Articles, officially the Articles of Confederation and Perpetual Union. First, it is useful to start the discussion on a legal topic with a motivating question. And I understand, just based on standing in line, that John Kowal did a little bit of this in his introductory remarks, but let me set the stage again. Why study the Articles of Confederation? After all, they are no longer in effect. But that simple response tends to minimize the significance of the Articles. As we all know, the Constitution of the United States is in effect, and the Constitution was ratified and adopted in the late 1780s, in large part due to the perception among many that the Articles were defective. And as we know, questions about the meaning of the Constitution are much debated today. So studying and discussing the Articles gives us a window into what the Constitution might be understood to mean. Second, the basics of the Articles adoption. As you no doubt know, the Declaration of Independence was adopted by the Continental Congress on July the 4th, 1776, almost 249 years ago to the day. The Articles were debated almost immediately after the Declaration, finalized by the Second Continental Congress almost a year later, but did not come into force until 1781 in the midst of the American Revolution, after they were ratified by all 13 of the colonies. So now you'll no doubt be wondering why it took so long, from 1776, 77 to 1781, but that's a question that one of my colleagues will be addressing in just a few moments. For now, let me focus on two issues. One, what was the status of national assemblies prior to the Articles? And two, what did the Articles hope to achieve? Specifically, how did they structure the national government and its relationship with the states? To start with the first point, there had been earlier pushes to increase cooperation among the colonies for decades, starting with what was known as the Albany Congress in 1754. And the reason for that is obvious. There was a need to help solve mutual problems. By 1775, the Second Continental Congress began acting as a provisional government for the colonies. And then in June of 1776, the Continental Congress appointed a committee of representatives to draft the Articles with John Dickinson of Pennsylvania as a chair. So the second point then, the Articles established what is often described as a weak national government with highly, highly limited functions and powers. They did so in part to preserve the independence and sovereignty of states, which was top of mind during the drafting and ratification process. In fact, the final draft of the Articles made clear that each state retained its own sovereignty. The Articles also left significant practical matters such as the status of Western land claims in the hands of individual states. And the Articles did not allow Congress to tax directly, but rather required it to ask states for funding, which was a hugely important matter to which I will return later on in the panel. For now, note that Congress had the power to regulate and to fund the Continental Army. This is, of course, in the midst of the Revolution, but it lacked the power to compel states to provide funding for the troops or to provide troops themselves. Finally, and significantly, the Articles established a unicameral body, that is, a single body to act at the national level. Exactly what that body was, a legislative branch, a plural executive branch, a judicial branch, a supranational body, or all of the above, or none of the above, was debated in the years that followed. And I'll stop right there.
Thank you. So, Professor Rakove, I'm going to pull you into the conversation next. And as Professor Bamzai mentioned, the Articles it took some time for the Articles to be adopted. It was a full year of intermittent debates, over 3 years for the ratification process. Can you tell us a bit about what took so long? What were the sticking points? Tell us the story of how the Articles themselves were ratified.
Well, first off, the story is somewhat episodic. Congress spent a couple months debating the Articles of Confederation in June and July on into August 1776, which would turn out to be a rather dramatic month in the history of the revolutionary struggle. They suspended discussion. They resumed it again when they, in the spring of 1777, came upon the same stumbling blocks they'd encountered before. And then in the aftermath of the victory at Saratoga, they resumed discussion with the real intention to get the Articles done and finished, published, so that Benjamin Franklin, who was then off as our sole minister in France, could proceed at that point to complete negotiating a treaty of alliance and commerce with the monarchy of Louis XVI. I think the main stumbling blocks, if you go back to the initial debates, there were basically three issues dogged the discussions. The first was the question of representation. The argument had arisen in the First Continental Congress, which met, of course, at Carpenter's Hall and not at Independence Hall, or the Pennsylvania State House. What would be the rule of voting? And you had these interesting arguments coming from Patrick Henry and others as to, on what basis are we acting here as delegates from the states, or are we not all Americans with a common cause, and maybe we should just vote as individual delegates? But they came to their state as colonially appointed delegates, and they agreed to vote by delegation. That issue continued to be discussed off and on in 1776 and 1777. I think there are two reasons why they could not make any progress on it. First, if you want to have some kind of system of proportional representation, it means you have to start collecting the data. And how you would do that in wartime when the American state or states are so sorely pressed to get everything else done would have been a real challenge with their administrative capacity. So that's one explanation. I don't think it's the most important. I think the most important explanation, as I argued long ago in my first book, is that decision-making in the Continental Congress was essentially consensual in nature. In most cases, it wasn't about who could get 7 votes or eventually 9 votes over a major issue. Congress could only act when it was agreed on what its course of policy was going to be. And if that's your underlying model of decision-making, then having a rule of proportional voting is not going to be, it may seem unjust on the face of it, but it's not going to be the dominant consideration. So the grievance survived, and James Madison, when he plots his agenda for the Philadelphia Convention in 1787, insists that we should have proportional rules of voting in both houses of Congress. But, that's a story that has to be told and resolved later. So that was problem number one. Second problem was how do you apportion the common expenses of the Union among the states so that the states can levy taxes upon which the Continental Congress will rely to maintain its own expenditures. It also actually have sources of income that will prove attractive to would-be European investors who may not expect to be paid off immediately, but would like to know that the new unions are going to be more or less financially tangible or fungible or whatever. And so here you have disagreement over what's the appropriate basis in terms of schemes of taxation for allocating the common expenses. You can make arguments about the value of land. You make arguments about do it on the basis of property. There's a common motif in this period that perhaps population is itself the best index to wealth. So if we just count bodies, we'll get a good algorithm or whatever for allocating the expenses. But that doesn't get very far, and in the end, Congress bogs down on this. The New Jersey, I suppose since I'm in Philly, I should say the New Jersey delegates kind of come up with, they wind up in a sense being the swing vote, and they come up with a complicated and wholly impractical scheme that the allocation of expenses should be based on the value of assessed property, primarily land values throughout the counties. Again, another scheme which might have some appeal in theory. It's going to be highly impractical given the circumstances of wartime governance. So those are the two issues that mattered most. But the one that was really decisive that explains why does it take so long, why does it take into the winter of 1781 to get the Articles ratified is the whole question of Western lands. Mm-hmm. It's a small group of primarily landless states, primarily, again, New Jersey, Delaware, and critically Maryland. Pennsylvania, in a sense, is a landless state because its western boundaries are fixed, but it has enough land, it's not going to worry. So those three states held out on ratifying the Articles. I should have added that when Franklin gets the victory at Saratoga behind him, the French conclude a treaty with us very quickly. And Congress is anxious to, at that point, is anxious to get its own authority confirmed. So Congress gets together, kind of rushes through a set of resolutions, I think the late spring, early summer of 1778, to get the Confederation ratified by all 13 states. That's fine, except Delaware, New Jersey, and Maryland drop out. And their argument is that the states which have, particularly Virginia, but not only Virginia, which have claims to Western lands are going to have this relatively profitable or lucrative resource upon which they can draw. So their ability to fulfill their financial debts to the Union will be fairly easy for them to resolve. The so-called quote-unquote landless states don't have the same resource. The other thing that's tied in here is that there are land speculators at work who are trying to validate their claims to Western lands, which essentially means the old Northwest Territory west of Pennsylvania, north of the Ohio River. It's primarily Virginia's grant. So Maryland holds out into the winter of 1781. Eventually the French put some pressure on them because the British are rampaging through the South at this point, and it's kind of a hell or high water moment to finish them. I think the key point you made is that by the time the Articles are ratified, schemes for amendment were already afoot. There's the first impost that already went out to the states in, I think, February 1781, some weeks before the Articles finally took effect. And Alexander Hamilton, I think particularly a number of figures in the Army already realizing that the Articles as drafted are wholly inadequate to the needs of the Union. We have to start thinking in bolder terms about a true national government.
But then amendments required unanimous.
So amendments to Confederation fall under the same rule as the original Articles. And that's why in the end, in 1787, particularly I think when Rhode Island more or less checks out, Madison and the framers and the Federalists realize we have to abandon the framework. We have to abandon the whole amendment framework. We're going to do it on some kind of super majoritarian grounds. If they're non-assenting states, well, tough luck.
Thank you. So, Professor Peterson, I'm going to turn to you next. And I think it's not a spoiler to say that the Articles, it didn't work out so well. The weaknesses were apparent pretty quickly after adoption. Can you talk to us a bit about the biggest problems that emerged with respect to how the government was structured and why things devolved so quickly?
Well, I think we can overemphasize sometimes the importance of the articles and their written structure. Because after all, by the time they were adopted, the United States had already been at war, had been funding a military, had already concluded its first treaty with France. It was doing everything a nation must do. And there was no time to wait for the articles. In fact, as ratification dragged on and on, Thomas Jefferson's opinion was, if we needed a written constitution, we have it in the Declaration of Independence. The final provision of the Declaration gives us the right to conduct war, conclude peace, engage in commerce, and everything else that nations have a right to do. So what were the problems with the articles? It's both a matter of how they were written, but also how their writing reflected the realities of the time, the political realities of the time. That included the fact that it was only at the local level that any administrative capacity existed in these early states. It's true that the articles didn't give the national government the right to tax, but it's unclear how they would have done so, especially at the beginning of the war, when there was a blockade of the ports. So taxing imports was not a solution. Even during the Constitutional Convention, when the founders were debating the taxing power, which would be so important, I think it was Gouverneur Morris asked, well, what exactly is meant by direct taxation? And nobody answered. Because the idea that the federal government could reach its hand into every American's pocket was just so preposterous as a practical matter. And in fact, the federal government didn't have an income tax until the 1860s. So what were the problems of governance? I think it was a crisis of confidence, really, combined with the difficulties of funding the war. At first, there was a wave of enthusiasm right after the Declaration, and we even had voluntary joins to the Continental Army. But that enthusiasm dropped off very quickly. And there were two main problems, I would say. One was Congress's obvious incompetence at managing the military and the war effort, which was its main job. The Army was poorly supplied. It was unpaid. The soldiers were starving. At first, the conscription periods were so short that soldiers returned home before they were competent soldiers. And the other was the currency crisis. And of course, these two problems were linked. Congress could not collect the funds it needed directly from the states, in part because states had their own issues, their own militaries to fund. And so it started printing money. It started printing money in that time were in the nature of bonds, papers that said, at some future time, the Continental Congress will redeem these in hard currency. And of course, that kind of currency relies on faith. Faith that the United States would be a going concern, faith that these bills would someday be redeemable. And the crisis in the war meant that that faith became lower and lower, and so the currency became, we had a runaway inflation problem as it depreciated more and more throughout it. By 1779, there was such a crisis that the phrase "not worth a continental" had entered general parlance. So why didn't the articles work? It wasn't just because of their structure. If it was just a matter of getting the words right, and if everything would have flowed very easily from getting the words right, then the articles were fine, because they said that states shall comply with all the decisions made in Congress, that states shall tax in order to defray the common costs of war whenever Congress asked them to. That wasn't the problem. The problem was practical, and the problem was one of allegiance, faith, confidence, which became lower and lower over the course of the war.
Thank you. Professor Neem, I'll turn to you next to, welcome, of course, any further responses to that question, but then also to talk a little more about civic virtue, which might be a little bit of what was embedded in some of what Professor Peterson was speaking about as well. This was seen as a critically important value in early America. To what extent were concepts of civic virtue embedded in the Articles, and why wasn't civic virtue enough to enable effective governance, as Professor Peterson was describing?
Yeah, thank you. And I like this question because it's about us, right? So if you think about the 1780s and the purposes of the Articles of Confederation, the purpose of the Articles is to maintain a confederation that will sustain these new republics. And so the thing we have to think about is, how do you sustain these new republics, right? What holds a republic in time and space, right? And if the character of, let's say, a monarchy depends on the quality of the king, as I tell my students, then the character of a republic depends on, and I look at them and they're a little nervous about that. Depends on the quality of the people, right? It depends on the character of the people. So the founders had the idea of civic virtue, which is the idea that in a republic, because it's a collective enterprise, in fact, a republic is a community, it's a commonwealth. And in a republic, the collective is the citizenry, and it's the job of the citizens to put aside their petty interests to serve the common good. And so many people today, and then also started to think about politics as, how do I achieve my interests? Where the entire premise of a republic is that the people are capable of putting aside their interests. So you have these republics that are dependent on the people, and the United States is going through an economic crisis, it's coming out of a war, there's some radical constitutional projects going on in every one of the states about how to create republics at the state level. And then you've got this league of friendship called the Articles at the level of Congress, at the national level. And they don't always align. And that's part of the problem, right? That the interests of all the 13 republics don't always align with the national interest. And so you have a built-in tension. I think, the framers of the Articles probably thought, well, the republic, the citizens will know that the needs of the nation are paramount because that's the only way to secure the republics against threats, foreign and domestic, right? That people will have to care for the welfare of the nation. But in fact, that wasn't working out. And so Madison does a study of all confederacies he can think about, ancient and modern, and he comes to the conclusion that confederacies tend to, if they're not well designed, they tend to fall apart, that there's always some fatal flaw. He calls them the vices of various confederations. But Madison loses faith, to build on this idea of faith. He loses confidence that the people themselves can get there, that the people of these 13 republics, without some national correction, will be able to see that common good. And he's sitting there in Congress, seeing the United States government go broke, seeing military threats on all sides in the West, in the Atlantic, in the Caribbean, and he's seeing that Congress won't survive. And if Congress fails, the United States fails, the revolution fails. And if Congress fails, that means these 13 republics that are fragile will fail. So that's Madison's perspective. But the citizens often, at the state level, aren't always convinced by that. So Madison is looking for a solution that will sort of align the interests of citizens with the interests of the nation as a whole.
Thank you. And just to pick up on what both of you were saying, I think there's a really interesting thread that I just want to pull on about this question of to what extent were the challenges with the Articles about structural defects versus other things, either challenges, just bad governance, or limits in terms of state capacity that had nothing to do with the Articles, but were just the fact that there was a war, there were lots of limits on the ability for an effective national government. And so I guess I would just welcome responses from the rest. If you were to identify, were there fatal flaws with respect to the Articles of Confederation? Was there something where structurally that really, there was no version without fixing that structural defect that things could have worked? Or not? Was it really more a story of other governance challenges that were really affecting the ability for the Articles to be effective? Anybody would like to, please.
So what Jack said before, that it was, that the Articles set up governance based on consensus, was a real problem. Because even when the states had 8 votes, they could not get to a decision on a very important issue. And especially after the war, this became a huge problem. But I think that to just tease out one of the aspects of this idea of virtue, for leaders at the national level, it was very clear that that virtue was commitment to the project of the whole. But Americans had declared independence in order to pursue what some saw as a very different goal, which was local governance, and to commit to the principle that it was only people who were actually represented in their governance that could have a say in how to commit the resources of the community. And during the Revolutionary War, that principle meant that states put their own citizens first, and they thought that that was the virtuous path. So if they would have had to take funds and provisions away from their own militia in order to fund the Continental Army, that was a losing proposition. If they had to demand that their own citizens allow officers of the Continental Army to quarter in their homes without due process, that was a problem for them, because they had committed to this project, becoming traitors to the only government they'd ever known, for real principles, and those principles meant republicanism at the local level, not commitment to a distant authority that demanded things that were difficult or impossible for the local public to provide without dramatic sacrifice.
Jack.
I think I'd build a little bit on what's just been said. To me, the dominant, well, first off, I'll say, in a certain sense, I think of myself as a Madisonian in terms of not only what I study, but increasingly how I think. And I think Madison's dominant analysis of what he called the vices of the political system of the United States pivots on several points, but from the perspective of the Articles, it pivots on the key point he makes in the 7th of 11 items, which discusses the want of a sanction of coercion in the Continental Congress, meaning Congress has no authority to coerce or compel the states to perform their duty. Madison then launches into what I think is the single most brilliant paragraph of political analysis in American constitutional history. He says, look, there are basically 5 causes, or 5 ways we can think about this. 2 of them are historical. The first is I think Johann and others previously intimated. Back in the day, meaning back in the mid-1770s, we simply assumed the states would do the right thing. We were all patriots. We're caught up in the so-called sunshine patriotism of 1774, 75, 76. We felt that enthusiasm would be enough. Turns out that was not true. Second, even in wartime, when we should have learned the lessons because of an external threat, we found the system breaking down. So even external danger doesn't always do the job. But then he launches into what I think, and I've written about this in various places, what I think is recognizably a game theoretic analysis of the problem of federalism. He says there are 3 other reasons at work here which will prevent us getting an adequate or fulsome level of compliance from the states. First is, states have a variety of interests, so we cannot assume that they're equally inspired to respond adequately in any given situation. Second, there's what I now call the running against Washington problem. Within every state, you'll find quarters of popularity. I think he's thinking first and foremost about Patrick Henry, who are going to have their own political interests to pursue, their own ambitions to court by opposing measures coming from the national government. And then third, what I think is the most ingenious argument, he says, look, even when we have a common interest, and we might actually agree on what the policy ought to be, if we have collective doubts about each other, no one's going to be the first to comply. So there will be a net drag in the system. So I think in that sense, and at that point, Master reached the conclusion, under these conditions, the operative phrase is, this situation will never fail to render federal measures abortive, meaning the system's always going to be prone to breakdown. So therefore, you need another system. That other system has to be, the national government has to be able to act legally in the full sense of the term. Unlike the Continental Congress, it has to be able to enact its own laws, execute its own laws, and adjudicate its own laws. Second point, I'll just make quite quickly, and it comes back to what Farah was just saying, there were particular moments in 1779, and I think more dramatically in 1786, when it's no longer clear what is the common national interest. 1779 has to do, there's a danger of peace negotiations when the British are occupying a big part of the South. What kind of peace settlement will you reach? It might be good for New England, not so good for North Carolina and Georgia, South Carolina and so on, which are facing military occupation. And then 1786, you have this great crisis over American rights to free navigation, the Mississippi River, which is dividing the Congress into blocks of 8 states and 5 states. And as Farah noted, for John Jay to negotiate the treaty that was in question, you would need 9 states to ratify. The northern states couldn't get to 9. The southern states had their 5, but it's just a formula for the question: do we really have one durable or perpetual confederation, or might it break up or break down into 2 or potentially 3 sub-confederacies?
That's fascinating. Johann?
One way, just to build on this, to think about this is, so Jay opens the Federalist Papers, John Jay, with an analysis of international relations, right? And so if you have a confederation of states, one of the primary purposes is military. It's to create a defensive league. And one of the things, just building on this idea of playing out how things might have worked out, is Jay points out that actually, if we don't find a way to cement the Union, the states, because of their divergent interests, will start reaching out to other alliances to pursue their goals if the confederation is not strong enough. And so if we don't do something to bind the states together, as the states pursue their separate interests, they may end up allying with Spain or with England, with indigenous tribes, with France, and they may find themselves embroiled in war with each other. And if that happens, this whole hope that these republics will sustain themselves over time, the states, the local republics, will sustain themselves over time, will disappear. And so there's a tension ultimately built into this vision coming out of the revolution of an active citizenry participating at the local level in their self-governance, and the kind of anarchic tendencies of the 13 states pursuing their own interests. And the people going to Philadelphia trying to figure out how to resolve that tension.
And I'll just give a reminder to the audience that please write down any questions that you have on your index cards. We're going to leave time at the end for this wonderful panel to answer questions as well. Farah? Farah, I mean.
It's true that this was a problem of how the Articles were written when the United States concluded its peace treaty with England, the Treaty of Paris. It could only agree to earnestly recommend that the states follow various key provisions in the treaty, including the provision that they wouldn't retaliate against loyalists and confiscate their property, something that the states found to be an overstep. And so immediately after the treaty was passed, and in part in reaction to the treaty, 6 states passed laws confiscating loyalist property out of pique that the national government would presume to regulate something so internal. So that was a structural issue. But how to fix it was a real problem. Madison's favorite solution would have been a prior veto power in the national government of all state laws before they went into effect. And he lost that vote in the convention. Washington initially thought there must be a power to force them by military means to comply with the national government. But eventually, Madison convinced the convention that this was impractical, that it would risk a constant state of civil war. And so what they were doing in the convention was trying to construct a structure that would motivate the various players in the system to act in ways that were mutually reinforcing instead of divisive. This is a broader application of the principle that Madison mentioned in Federalist 51. They need to make ambition counteract ambition. How did they do that? It's not just, again, it wasn't just getting the words right, whereas they got them wrong in the first place. It was about constructing different levels of government, different forums for the resolution of governance issues that would behave in ways that were more conducive to national strength than division.
Thank you. So we've already started talking about some of the different controversies, crises, challenges that we saw during the period of the Articles. Professor Bamzai, I'm going to pull you in now to talk about another one of these, which was the impost controversy, the call to give Congress power to levy a tariff on foreign imports. Can you tell us a bit about that history?
Absolutely. And in fact, as my co-panelists were talking, I was reflecting on the very deep question that Farah kicked off and then Jack and Johann weighed in on, which is how much of the breakdown of the Articles of Confederation is dependent or is the result of character? How much of it is character and how much of it is words? The text, how much did the text get things wrong versus were the American citizenry the issue? And I think these questions are maybe not related to one another, and they're reinforcing in the sense that words can have an influence on people's characters. And one way to address that broader question is the very, very significant criticisms that were lodged against the Articles about the fact that the Continental Congress could not directly raise taxes for the national government. So the Articles had some language in them that preserved this robust conception of state sovereignty. In fact, they declared that each state retains its sovereignty, freedom, and independence in every power, jurisdiction, and right, which is now by this confederation expressly delegated to the United States. And then with respect to taxes in particular, the Articles said, and this is a quote, that they shall be laid and levied by the authority and direction of the legislatures of the several states within the time agreed upon by the United States in Congress assembled. So there's some language in there that sounds as though it's imagining and almost requiring states to levy taxes, but there's some language in there that suggests that, Congress might have to recommend to the states that they levy taxes. And in fact, then in 1781, during the Revolution, shortly after the Articles were adopted or around the same time, Congress requests that each state vest a power in Congress to levy a tariff of 5% on foreign imports. And the initial holdout, as Jack mentioned earlier on in the conversation, to this proposal was Rhode Island. And they rejected the recommendation through a letter from the Rhode Island Speaker. And the Speaker gives a number of reasons for why Congress should not get this authority. But an interesting one is that it would introduce into this and other states officers unknown and accountable to the states. And so it's against the Constitution of Rhode Island. So that is, again, picking up on this theme that occurs during the American Revolution, that there should be some sort of accountability that these officers have to the people. And the Speaker of Rhode Island is saying, who are these people who are going to come into our state from outside the state in order to raise taxes by this 5% tax on imports? Well, so that 1781 proposal doesn't work. And in 1783, Congress tries again, and they say, well, we'll have a duty of 5% on goods, and they accommodate Rhode Island's objection in a couple of ways. They say, we will allow the impost to expire in 25 years. And then second, they say, the states can appoint the tax collectors, and we will have the authority to remove them. So there's some sort of accountability mechanism that's being built into this new taxing regime. That doesn't quite work. And in 1786, Congress tries again, And it's New York that is the holdout at this point. And as you can imagine, New York, both as the state that it's the key to the whole national project working, because so much of foreign commerce is going through its ports. So in 1786, the state legislature in New York enacts an impost law that does grant Congress some authority with respect to duties on imports, but it vests in state officers the power to levy and collect the duties. So by implication, the tax collectors are responsible to the state, not to the national government. And Congress recognizes this measure as effectively a repudiation of its own request. It says to the New York governor, George Clinton at the time, hey, please convene a special session to reconsider the bill. And the special session also results in another rejection of this impost authority. So what you can see is that in 1787, there are these years of twists and turns, and ultimately they lead to New York's rejection of Congress's authority to implement this impost effectively. And that 1787 rejection is the death knell for the proposal. And James Madison, when he is then spelling out the flaws of the Articles of Confederation in 1787, he places this inability of Congress to raise taxes at the very top of the list. And he says New York's rejection was not just the death knell of the proposal, but the effective death knell of the Articles. In fact, Alexander Hamilton has some notes for speeches that he delivers at the Constitutional Convention. And among the notes, he says, impost begat the Constitutional Convention. Begat, gave birth to. So I think that this whole controversy both gives a sense of how much of this was related to character of the people of New York, who perhaps wanted to control the duties that they could impose on foreign imports into ports of New York. And there was a faction within the state of New York that had an economic interest in controlling those duties. And it also related to the words that you can see in the Articles of Confederation. How much authority did they actually give the national government? Along with all of that, there were disputes within the New York State Legislature about whether the New York State Legislature could delegate to the federal government this additional authority. And those questions of delegation become front and center when the Constitutional Convention kicks off. Perhaps we'll return to that at some point, but I'll stop right there.
No, thank you for that. Speaking to, and I do think it's fascinating just looking at, I read your article and how just this concept of how they were saying, well, we can't do this. Our state constitution says that we are barred from cooperating in that way, and just what a different mindset than in our contemporary, under the US Constitution, where obviously we have a supremacy clause. You're not going to have a state constitution barring cooperation with the federal government in that same way now. So I thought that was just a fascinating example of just the very different mindset that existed in the period of the Articles. We have a few more minutes before turning to Q&A, so I'd love to spend a little more time talking about some of the various crises in the lead up, and would also welcome anybody who'd like to weigh in on just what was top of mind with respect to the framers when they actually gathered in the Constitutional Convention. What were they worried about? What was the experience of governance or other crises that were most prompting, were prompting them to focus on the questions they focused on during the Constitutional Convention? So, maybe I'll pose that question to all of you, and Professor Peterson, when you answer, if you could also maybe talk a bit about Shays' Rebellion as I think one piece of the story of the lead up to the Constitutional Convention as well. So maybe I'll turn to you first.
Okay. Well, so one thing you just said piqued my interest, which was obviously the Supremacy Clause means that under the new Constitution, states could not do the things that they did under the Articles, but that's just not the case. The supremacy of the federal government was years in the making, and it wasn't fully complete or settled until after the Civil War. Was one of the accomplishments of the Union Army. In the 19th century, there are innumerable examples of states rebuffing the authority of the national government. To think of two, in South Carolina, there were what they called Negro Seamen's Acts. That is, if free black sailors docked in Charleston or any other place on the coast of South Carolina, they were not allowed to wander freely. They had to be confined to jail until their ship re-embarked in order to protect South Carolina from the intellectual contagion that free black sailors might introduce. This was a violation of the nation's trade agreements with Britain. Many of Britain's merchant sailors were free black sailors. They were a large proportion of the British citizens that docked in South Carolina. And Britain's foreign ministers were continually raising this with the Secretary of State, but there was absolutely nothing they could do about it. Also, in the War of 1812, the Constitution was as much a military as a civil document, and it established that during times of invasion, the commander-in-chief of the army would also be the commander-in-chief of the militias. That is not how the New England governors decided to interpret those provisions. And because as a practical matter, they were in command of their own militias, they declined to participate in the invasion of Canada, which was one of the national government's primary military objectives. So these
That's a great point. It was a long path to get from there
very
to,
long
to
path
here today.
to supremacy. So, you know, why? Why did the national government become supreme? It's a matter of cultural change, really. And to the extent that they gleaned some new powers immediately, it was in part because the experience of the war and the decade, what we call the critical period afterward, convinced many that it would actually be useful to have a national government in charge of, for example, foreign affairs. Without that broad-based agreement, it's unclear that Washington would have consolidated power so quickly. And of course, we have to take into account that it was Washington who was at the head of the new government, a person who had garnered quite a bit of charismatic power. Okay, so what was most important? It has to be in part the tariffs. The power to impose tariffs in the Constitution was very important. It helped fund the debt of the Revolutionary War. It was, in fact, the way that the United States government was funded for 100 years. And imposing other kinds of taxes, excise taxes, led to conflagrations like the Whiskey Rebellion. It was very dangerous for the government to impose taxes in other ways. The Supremacy Clause, of course, and the creation of a federal court, but also the Contract Clause. It has to be listed as one of the main prompts, one of the main gains of the Constitutional Convention, and that's because of things like Shays' Rebellion convincing so many that the real fact of democracy in the states, the fact that agrarians in the west of these states, debtors, the lower classes could combine and implement legislation that victimized creditors and other financial elites. That was a major prompt to the Constitutional Convention. And at some points, convention delegates admitted to themselves that this was perhaps the most important thing they'd come together to establish.
Great. Professor Rakove.
I want to back up on Farah's concept of supremacy. So the Supremacy Clause says, this Constitution, laws made in pursuance thereof, and treaties made under the authority of the United States shall be the supreme law of the land. Nothing in the Constitution, the laws of the states to the contrary, notwithstanding. I may have mangled the second half there, but that's roughly the gist of it. You have to ask the question, what makes the Supremacy Clause itself supreme law? And it's a bit of a trick question because one of the underlying puzzles of the Constitution is how, or really the constitutional history more generally is, how do you turn a Constitution into supreme law itself? What differentiates a Constitution from other forms of legal action? And there is a somewhat technical but also conceptually powerful argument which says the documents approved by a legislature or by a body acting in a legislative capacity are themselves only legislative in nature. And because one legislature cannot bind its successors, any constitutional decision made by a legislature will not itself be fully constitutional in the robust, complete sense of the term that we now use. So it is one of the great puzzles of from 1776 down to 1787. How do you make a constitution fully constitutional? How do you make it into the supreme law of the land? And the answer to this is what it's worked out first in Massachusetts in a somewhat complicated and messy and protracted way, and then it's generalized more specifically in 1787, 1788. Unlike the Articles of Confederation and its amendments, you cannot submit the Constitution to the state legislatures. Their only role will be to arrange for the election of delegates to the so-called ratification conventions. The first of which met was, of course, the one that met up the street here in Pennsylvania in the fall of in the fall of 1787. So those conventions, even though we could say this is a kind of a legal fiction, nevertheless, I mean, the conventions are representative of the people, well, so are the legislatures. But if you call them for a unique purpose, they can only act constitutionally and not legislatively. The nature of their action is therefore differentiable from ordinary legislation. So the authority, what makes the Supremacy Clause supreme is not only its language per se, but also the foundation, the underlying foundation of the Constitution itself, which is to come up with a method of how do you distinguish the Constitution from other forms of legal action.
More on what was top of mind with respect to the framers when we entered into the Constitutional Convention. Professor Bamzai?
Yeah, so I've already talked about the impost controversy, and what's really interesting about that whole controversy is that there's both the economic angle, obviously the control of taxes is very important to the functioning of either the state or the national government, but there are also these legal points, which I think if we were to distill them, might amount to the following. It is, we already have our own Constitution, thank you very much. We have the New York Constitution, and we cannot violate our own Constitution by delegating this additional authority to the national government. And there are all kinds of intricacies in the claims people are making about the New York Constitution at the time. But we can set those aside and just think about the broader question of sovereignty. Where does sovereignty reside? Is it in the states or is it in the national government? And that question, which is at stake in the impost controversy, it then plays itself out into the steps to the Constitutional Convention in 1786 and 1787. And so in the article that Alicia kindly referred to just a few moments ago, I have a little summary of, there's some letters exchanged by John Jay, who is at the time the Secretary of Foreign Affairs for the Confederation, and George Washington, who's out of office. And Jay's asking, well, are these state legislatures authorized either by themselves or by others to alter constitutions? Can they alter their own constitution? And he says, well, maybe the people who would hold commissions and go to the Constitutional Convention, by virtue of those commissions, they couldn't retrench on or extend the powers that are conveyed to them. So they'd be limited by their own internal constitutions. And there's a question at the time the Constitutional Convention is being planned, whether there could be alterations in the state governments or in the national government, and that would ultimately play itself out in New York through this series of resolutions when delegates are being selected to go to the Constitutional Convention, asking that the delegates not adopt any changes to the articles that are repugnant to or inconsistent with the Constitution of this state, New York. And somehow Alexander Hamilton is able to maneuver in the state legislature of New York and ensure that that resolution is not adopted. But in fact, there's a commission that is given to the various delegates to the Constitutional Convention. There are two, Abram Yates and John Lansing, and Alexander Hamilton is the third. And two of them, Yates and Lansing, they depart in the middle of the convention, and they say, Well, we were given limited and well-defined powers by the state of New York, and we can't possibly go beyond that. We can't construe these powers that we were given in our commission to come up with a new constitution and abandon the Articles of Confederation. And this then leads to this very consequential rebuttal to the argument which you can find in Federalist 40, which is authored by James Madison, where he's talking about how the powers of the convention can frame a national government. And even in the last gasp, when you approach the ratifying convention in New York, there are various of the anti-federalists who say, well, instead of revising and altering the provisions of the Articles of Confederation, these folks in the Constitutional Convention, they've just come up with a new Constitution of the United States, and it violates our commissions that we gave to the various delegates. So I think that the really important taxing and economic issue plays out both on a political and policy-based trajectory, as well as this set of legal questions about what's the source of sovereignty writ large.
President.
Yeah, I guess just sort of pulling these pieces together, if you think about it, right, obviously, and this is somewhat trite, but it's really important, is what is on the people's minds as they're walking into the convention is how do we make the Union survive? How do we ensure the United States doesn't go belly up? And that is the fundamental question everyone's bringing. But then as you're sort of hearing this conversation, there's part of it that you've got a bunch of tinkerers, right? And they're like, okay, well, that's an easy fix. You give certain new powers to Congress under the Articles, and a lot of those powers end up in the Constitution. Supremacy in certain places, taxation authority, issues of Western lands, all these kinds of problems that the Confederation couldn't solve. Let's resolve them by granting more powers to the Congress. And so there's a kind of practical group of people who are like, let's just go in and fix these problems and we'll have a stronger Confederation. And in fact, I think to your point, when Madison sort of shows them what he has in mind, it opens a whole new window, right? Like this, and that window could be a source of fear and panic, like this is a threat to our sovereign republics, but it also is an act of imaginative creativity, because it's a moment where people start to see the possibility of another kind of way of organizing the people of the United States and putting them together. So you also have, so we can see the convention simultaneously as a kind of group of tinkerers who like put a bunch of powers, and the remnants of that is in the contract clauses, all these language specific terms that enter into the Constitution, but then this imaginative act that opens a window to rethinking the very nature of the United States. And those things sort of come together in Philadelphia.
Thank you. I'm going to turn now to some questions from our audience. So the first question, and this is directed just to anyone on the panel that would like to engage, were there ideas in the Articles that you think the Constitution's drafters should have preserved? So were there aspects that we should be trying to resurrect, or at least at the time that the drafting took place should have been maintained?
Well, I have a somewhat quirky one which relates to the current state of the body politic. So let's assume, as I am now doing increasingly, that we're at a moment of constitutional failure, not wholly different from 1787. I've started, and Farah and I were talking about this briefly before, I started to wonder, suppose, I think the United States should try to remain a superpower, but, you know, I live in a blue state, and I've always lived in blue states most of my life, and perfectly happy to do so. I found myself wondering about one of the core conceptions of the Confederation is the notion of internal police. Actually, when you talk about sovereignty under the Articles, there's a kind of external issues, you know, war, diplomacy, primarily, and then Article 2 kind of, you know, I think it's a phrase that Connecticut delegates in particular, like the idea that a state should retain control of its own internal police. Police in the police part of the 18th century, 19th century, we no longer use it the same way. When we think police power, we think the police, the cops. But police power then meant the general authority of a jurisdiction to legislate broadly for the collective wealth, health, and safety of its population. You know, living where I do in California, feeling we're actually pretty well governed in terms under which I'm comfortable. I was wondering, well, why not, if there are fundamental social differences of a kind between for better, for worse, red states and blue states. Why not a confederation? I mean, to be fair, we can set up a great healthcare system on the West Coast. We'd start with the 3 coastal states, California, Oregon, Washington. We got to bring in, probably bring in New Mexico and Arizona's in between, so squeeze them in. They have a lot of retired old people, so they want to have a good healthcare system. So take that as one example. I have found myself thinking somewhat wackily, but not implausibly, about the idea of what would a contemporary confederation look like.
Anyone else want to?
Well,
I can't think of one. I think I'm, in general, in favor of the changes that were made over the course of the 1780s and result in the Constitution. But there's just, I'll use it as a launching off point to one theme that we've not addressed in our remarks up to this point, and that is, as I mentioned early on, the Confederation, the Articles create this unicameral body, and it's just one body, and it does all the national business. Whereas the folks who write the Constitution, they split, as you well know, the federal government into 3 branches, the executive branch, the legislature, and the judiciary. And this then has various consequences for how we implement policy through the national government. So,
but Aditya, it's critical to note, and we're easily confused about this, the Continental Congress was not a legislature. It operates with legislative procedures. When it has roll calls, it appoints committees, they present reports, and familiar modes of deliberation. But in terms of the rather nebulous conception of separation of powers, the Continental Congress is actually an executive body which operates under legislative procedures. And I think the best phrase for this is one that comes from a guy named Thomas Burke, who was a truly states' right-oriented delegate. Actually, the main author of, the main interpreter of, I think of Article 2. Burke calls Congress a deliberating executive assembly, which captures the essential ambiguity of the institution itself. It looks and sounds like a legislature in some ways, but its powers are actually quite different.
Yes. Professor Neem and then Professor Peterson.
No, just one quick thing that's building on these comments is, in the 19th century, they often talked about the Union. And so for us, when we think about the 1780s and the formation of a national government, we're living in a reality that imagines a national government that's post-Civil War and post-New Deal. So we're imagining a national government that, as we're seeing in the news today, has all these levers that determine the stability of almost every institution in the country, right, private or public. And because of its capacity to generate and distribute wealth through taxation, because of its immense police power, immense power over policies all across the Union, and so all across the United States. And a 19th century understanding would have been that this was a union, and you're fighting for a union so conceived that where there's a lot of local distinction and difference. And those local differences were handled at the local level. And they just imagined the United States very differently than we do today, living in a world that is so national. Now, just to be clear, some of the benefits of that national has been civil rights, right? That it's been the national government that's generally been interfering with local governance on behalf of civil rights, and regulation of businesses when they went national, right? When they could no longer be governed by local law. But at the same time, I think you're sort of asking us to sort of imagine are there different ways of imagining how the pieces fit together. And in the 19th century, they wouldn't have our understanding of what the nation looked like. They would have had this understanding of a union still.
Professor Peterson.
Right, so I was just thinking as Aditya was talking about this concept of the all-in-one deliberative executive assembly. And I mean, you could say that this is one of the problems of right now, and part of our constitutional crisis is, to borrow a phrase from Madison, the executive is absorbing all powers into its impetuous vortex, right? Trying to usurp the powers of the judiciary, rule by executive order instead of delegating this kind of legislative authority to Congress, and that's the problem. And one of the gains of the new constitutional system was different forums that could be captured by different interests at different times and different procedures of decision making. It's through these overlapping, these redundancies in government that we maintain liberty, because it's just more difficult to establish despotic rule when there are different bodies that have to commit to and be involved in that rule. Anyway, I think that the thing that the Constitution got wrong was the Fugitive Slave Clause. This is not a problem for us today, obviously, but the Fugitive Slave Clause meant that the pre-Civil War United States was not half slave, half free, as Lincoln put it. It was, in some senses, all slave, because if a master or his agent has the right to pursue a slave into a free state, the lash and the chain goes with him. And I just wonder what the nation would have looked like in the antebellum period without that constraint.
Turning to another question, were there different stakeholders involved in drafting the Articles versus the Constitution? And if so, did that inform the different approaches of those documents?
As a stakeholders, I find that a hard concept to work in here. I mean, I think I suggested before, the interests that mattered most were the claims about Western lands. Mm-hmm. So I mean, those are stakeholders almost in a literal sense of the term, like let's survey the land and who owns it, or who has a plausible claim to it. You know, again, you go back to, I mean, I think the decision just made that Congress, the Continental Congress lacks legislative authority in the ordinary sense of the term. So I think stakeholding is defined in a certain sense, just think out loud on the subject, by the existing legal regime that affects one's daily or recurring actions, that all the authority that really matters devolves to the states. And, you know, I think these guys are, you know, to be honest, I think mostly they were trying to, let's go back to 1776, mostly they were trying to put together in the spring of 1776, a kind of platform of action that would prepare the emerging United States of America for an ongoing conflict. So that meant the states had to resume legal government and not get rid of the revolutionary apparat, which had operated since 1775. We had a draft Articles of Confederation in part to, you know, make palatable and comprehensible the authority of the Union, but also I think as a major part to attract interest from France. And the third committee appointed was the one that John Adams basically did to, you know, to come up with a plan of foreign treaties. So that was, you know, that's not stakeholding in the narrow sense. That's stakeholding in the sense when the Articles were drafted, what were the main policy objectives that had to be fulfilled. So we had to get legal government up and running in the states. We had to do something analogous, not legal in the robust sense of the term, but to make sure the Confederation actually has some kind of bona fide visible existence. And why do we have to do this? Well, we can't win this war without French support, and the French are not going to rally to our side if we don't demonstrate our own viability and sustainability, and if we don't, you know, and if we don't kind of provide a victory to give them the incentive, you know, to come in and assist us.
Just briefly, I could say, like, there was just a whole new generation of people who then become involved in politics over the course of the 1780s. And so names that are familiar to us, people like James Madison and Alexander Hamilton, take on a larger role at the Constitutional Convention. And names like, say, John Dickinson, who I mentioned earlier on in the talk, or Thomas Burke, who Jack mentioned, or Roger Sherman. These are the towering figures of the early 1780s. So we end up with a group of individuals who had experience in national politics, and that's how, at least one reason perhaps, in the ways in which the Constitution and the folks who are there at the convention are different from the people who were there earlier in the decade.
I think one more question. In what ways is faith still key to sustaining our system of government, a civic faith? And at a time when we're seeing declining trust in our institutions, does history offer lessons for how to keep that faith alive?
So the founding generation was, I think faith is the wrong word, because the one persistent theme of this generation is suspicion and hostility toward government officials, a feeling that power corrupts. And so it was important not only to establish frequent elections and rotations of men in the offices, but also constant vigilance in case what this generation considered the inevitable would happen, which is that people would try to accumulate more and more power. So it was not so much faith in the government or even in the Constitution to maintain the government. It was taking seriously the power and the responsibility of the people to maintain their own freedoms. That's what happened in the Revolutionary War, and that's what you see in the early Republic.
Anyone else like to? Yes.
I think that at a moment like the one we're in right now, faith does matter. I think we've lost faith, but we haven't just lost faith in our institutions, we've lost faith in each other. And I think it's right that part of what defines the 1780s, and in fact all of American history, is a suspicion of government. But what enables, the question is, what enables people to overcome that suspicion and work together? Because there's never been a moment in American history where the people have all agreed. There's never been a moment in American history where we haven't had the problem of pluralism. There's never been a moment of American history where we haven't had inequality. But there have been moments in American history where we've been able to overcome them. And today, part of it is we've lost a sense of ourselves as a people. And one of the things the Constitution did create, and this is both the challenge and the problem of living in a very large republic at a continental scale, was a nation. And a nation is a group of people who see themselves together. And we may not have had that sense of nationalism had there not been a national government to which we were voting for direct representatives and where there were a judiciary acting directly upon us. In other words, where we became stakeholders in that government in a way we're not, for example, with the United Nations. That in a way is a kind of parallel to Continental Congress under the Articles. And so if we lose the faith, not just in popular self-government, but that the civic faith that we are a people with good intentions, and we start to see ourselves as distinct, then our institutions become unworkable. And we're starting to see some of that now. So I think the question becomes, how do we recreate that faith? How do we, how do we start to see ourselves as engaged in a common project, a common Republican project again? Is it through increased participation in local civic institutions? Is it by some of these other solutions of devolving power? Is it something else that brings people together across what are increasingly becoming mostly cultural divides? And so I think that's a really good question, because somehow without that faith in our systems and each other, we're not going to sustain them, and then we'll lose them.
So I'd like everyone to just bring us home with one thing you would like the audience to walk away from today, and I'll just go down the line.
So,
no pressure.
no, the one thing I would say, a lot of these problems, I was reflecting on Johann's remarks just a moment ago, that you might perceive to be a part of American society today, they have their analogs in the past. And there are different ways in which people navigated them at that time, and people will navigate them, and I'm optimistic that we will do so in our time today.
Yeah, I guess I want to echo that. That I think the one thing I would want us to take away is that this really was the 1780s was really a crisis time for the United States, and the solutions they came up with had their flaws, including the compromises over slavery, including perhaps the way they structured the legislature. But they were solutions to specific problems at the time. And so what I ask is, as we look at our problems of the time in the spirit of the framers of the Constitution, how do we solve them? Like, these were problem solvers, and they weren't writing in stone. They were writing ink on paper to respond to the very particular issues that were facing the United States at the time. And that if we approach them and ourselves that way, maybe we can start to do the same.
Professor Peterson.
Well, I guess the most important thing to know about this period is that it was founded in the belief, in the audacious belief, that rule by the people themselves is possible. And the distinctions between the Articles of Confederation, the new Constitution, they're about how to best secure a rule by the people themselves, how to protect the people from irrational majorities while maintaining that popular authority, and where specifically the people's power could be momentarily lodged in government, where it would be least dangerous. That was the project. How can we allow the people to rule themselves? How can we rule ourselves? Which in a world of monarchs was really special. And it continues to be the theme of our government. We engaged in civil war over which people are part of that polity, or which values do the people support. And it is as important now as ever to make sure that rule by the people doesn't fade.
Professor Rakove.
Well, I spent the last 55 years thinking about the origins of the American Republic, and I still find I have new questions to ask, and new problems to deal with, and new things to worry about, and I think a lot about what they got right and what they got wrong, starting with the equal vote in the Senate and the Electoral College, but that's a subject for another day.
Thank you. Well, thank you to our wonderful panelists for the conversation today, and to the audience for all of the excellent questions. I'm sorry we weren't able to get through all of them. We're going to break now for lunch and then reconvene to hear a keynote address from Representative Jamie Raskin. So again, thank you to our wonderful panel.